Okay. Hi, I'm Cheryl Ann Amendola, and welcome to History in the Kitchen. I've been trying a little bit of new technology lately, so that maybe I can see your comments on another screen, but I'm not getting that to work, so that's okay. This is History in the Kitchen. I am Cheryl Ann Amendola. I am your hostess. And thank you so much for joining me again this week to learn about the origins of the Supreme Court, more specifically, the origins of judicial review, and then do a little bit of exploring about Ruth Bader Ginsburg and her life. As you can see today, I am dressed as the notorious RBG herself, and I'll talk to you a little bit about her collars because I think those are actually pretty interesting later on in our episode. If you would like to follow me, you can feel free to follow me on Facebook. My Facebook page is facebook.com/teachinghistoryherway. I also have a blog where I share teaching tips, history tips, different things, different facts about history. I share my recipes and the things that you learn from History in the Kitchen every week on my blog. It's teachinghistoryherway.com. You can also follow me on Instagram. Teaching History Her Way is my username on Instagram, or you can also follow me on Twitter. My handle on Twitter is History Her Way because Twitter didn't give me enough characters to do my whole thing. I would love it if you would follow me as I share things throughout the week. I find some really interesting history stuff, or interesting to me, that I like to share with you. And we're also going back to school really soon, so I'll be sharing some things that I'm doing in my classroom, both hybrid, so virtually in the room, things that I'm doing with kids together. It's good for you if you are doing hybrid. I'll have some stuff for you if you're doing digital learning and if you're doing homeschooling as well. So I hope you'll join me. One last thing before we get started, I really hope that you'll share this video as we watch it. The more people who share it, the more people I get to share my love of history with. And I love history. I think it's really important for people to learn about their past so that we understand where we are in the present, and hopefully, if there are things that need fixing, ways to fix it. All right, so today we're making Ratatouille. It is a recipe from Ruth Bader Ginsburg's husband, her late husband. He was actually quite the chef. She is quite the foodie. She has a lot of favorite foods and a lot of favorite restaurants. But her husband was the chef of the household, and Ratatouille is one of the recipes. You can find this recipe and a whole lot of other really great recipes in the American Bar Association's new free online cookbook that they put up in celebration of 100 years of women having the right to vote. So if you would like to see this recipe and a whole lot of others that were submitted by justices and the like, you can check out the American Bar Association's website, and I'll also post that on my blog for you later as well. So you're going to need a couple of tools today along with the ingredients that I gave you. You're going to need to be able to saute, so take out a saute pan if you have one. You're going to need at least 6 tablespoons of olive oil, so I just have the whole Costco pack of olive oil here. And you are going to need a slotted spoon to toggle the recipes, to toggle the ingredients back and forth. And you're also going to need a large bowl because we're cooking one ingredient at a time today, and we're piling it up in the bowl until we're all done and we're ready to eat it. So I am super excited about today's recipe. I'm super excited about today's topic. I love talking about the Supreme Court. My love for the Supreme Court actually came from a college professor that I had at Montclair State University in the early 2000s. And Dr. Nichols actually made us argue Supreme Court cases between each other. And one time I had a partner who didn't show up for class the day that the project was due, so I had to argue against him. And it was really scary, but also really fun at the same time. And he sparked my love for the court, and I hope that I can share that love with you today. All right, so first of all, let's talk about the Supreme Court, what it is and what it isn't. The Supreme Court was established in the Constitution in Article 3. And in Article 3, the Supreme Court the Constitution gives the Supreme Court certain powers of jurisdiction. So cases that it can hear first, that's original jurisdiction. So that's when a case gets sent directly to the court. It doesn't go to any lower courts first. And it also gives it appellate jurisdiction. That is cases that go to the Supreme Court after it's been heard in a lower court. And it can be basically any lower court, but there is a process of appeals that most cases go through. That is long and circuitous, and I will talk about that in another episode. So, for original jurisdiction, the Supreme Court can only hear cases that are between ambassadors and consuls and public ministers, ones in which a state is a party. Those are the only kinds of the only kinds of cases that can go straight to the Supreme Court for original jurisdiction. Today we're going to talk a little bit about the power of judicial review. How did the Supreme Court get the power to look at a law and say whether or not it is constitutional? Does this law go with the rules that are stated in our Constitution? And that is not a rule that's in our Constitution itself. If you look in Article 3 of the Constitution, or the entire thing, the whole Constitution, nowhere in it does it say the two words together, judicial review. This is a court power that is a traditional court power. It's one that they got for themselves. At first, the Supreme Court wasn't very powerful at all. In the 1800s, in the early 1800s and the late 1700s, in the period between 1787 and 1803, the Supreme Court really didn't do much of anything. It wasn't very respected. The first Supreme Court was actually in the basement of the Congress, or in the basement of the Capitol building, excuse me. There was they weren't important at all, pretty kind of like whatever. And our government system is based on three branches: judicial, legislative, and executive. The executive and the legislative branch had lots of power from the very beginning, but the judicial branch was like, hold on a second, we're like a joke. Nobody really listens to us. We have all of these minor cases. So the power of judicial review is really important for the Supreme Court so that what the Supreme Court does has some teeth. So all of this starts when John Adams is president, and John Adams was part of the Federalist political party. They made some terrible mistakes during John Adams's presidency, and there was absolutely no way in the election of 1800 that John Adams was going to be elected ever again. Never, ever, ever, ever going to be elected again. He did some things that were actually pretty unconstitutional, but the Supreme Court didn't have the power to say that at the time. But people knew, and they were not very happy with John Adams and the Federalists. So in 1800, Thomas Jefferson actually wins the election, and that makes John Adams something called a lame duck president. And your lame duck president is a guy whose term is over and he's waiting for the next guy to come in. So while John Adams is a lame duck president, he tries to figure out the very best way that he can to make it so that Federalists stay in government. He wants there to be this Federalist balance because John Adams and the Federalists are actually petrified that the Democratic Republicans are going to ruin America. Does this sound familiar to you? All right, so what John Adams does is he's got this brilliant mind and it's buzzing around and he's like, aha, I know what I'll do. Justices have lifetime appointments. If you are a federal judge, the only way that you can be impeached is if you have bad behavior. So you have a lifetime appointment under good behavior. Or another way that a justice is no longer a justice is that they resign. So those are the only two ways that a justice is going to leave the bench. So John Adams sees this incredible opportunity to throw Federalists in for life. They're never going to be gone. So he makes as many midnight appointments, so last night appointments of federal justices as he can. And his Secretary of State, John Marshall, is in charge of delivering all of these commissions, all the pieces of paper that say, oh, you're a judge, congratulations, you got the job, to these people. Well, time runs out in John Adams's presidency, and there are 6 or so commissions that aren't delivered. So he leaves them on the Secretary of State's desk. John Marshall was the Secretary of State under Adams. Under Jefferson, John Marshall is the Chief Justice of the Supreme Court. So I want you to keep in mind that conflict of interest, okay? So John Marshall leaves these commissions, 6 commissions or so, on the desk of the Secretary of State, expecting that the next Secretary of State under Jefferson, who is James Madison, is going to deliver them. Well, James Madison gets to his desk and he's like, look at all these Federalist appointments. What, Jefferson, what should I do with them? And Jefferson's like, Federalist appointments? Those are forever. Tear them up. So he does. James Madison never delivers those commissions. Now, cue in my friend, Mr. William Marbury. Mr. William Marbury's commission was in that pile that was never delivered. Okay? So James Madison doesn't deliver the commissions either. William Marbury gets wind that he never gets his commission, so he sues James Madison. Hence, Marbury versus Madison. It goes straight to the Supreme Court. And what William Marbury wants is he wants the Supreme Court to issue a writ of mandamus to James Madison to force him to deliver the commissions. The writ of mandamus is a power given to the Supreme Court. They're given the power to issue these under the Federal Judiciary Act of 1789. Okay? So Congress gives the Supreme Court this power of original jurisdiction to issue a writ of mandamus. All right. So that's where we are so far. No, everybody's not getting his commission yet. So in this lawsuit, John Marshall is like, okay, I have two choices. My first choice is I can force Jefferson and Madison to deliver this commission. And they could totally ignore me, and the Supreme Court can look completely powerless and stupid. My other choice is to take this power away, this power of writ of mandamus as original jurisdiction away from the Supreme Court. But then I establish judicial review because I have declared a law of Congress signed by the president unconstitutional. So Marshall goes down this avenue, and what he says in the decision in this case is, one, William Marbury, of course you should get your commission. John Adams signed it. It's sealed. The only thing standing in the way is the delivery. Number two, he says to William Marbury, yes, you did absolutely the right thing asking for a writ of mandamus, forcing Jefferson and Madison to deliver the commission. Yes, you did the right thing. You followed the law. Three, except the law you followed is unconstitutional. Sorry. The Constitution does not give the Supreme Court the power of original jurisdiction in cases of writs of mandamus. So, sorry, William Marbury, you came to the wrong court. You don't get your commission. So, while they lost 6 Federalist judges, John Marshall brilliantly concocts this idea of judicial review. And the Supreme Court has been using judicial review, this power that they attained in 1803, since 1803. We see it every year when the Supreme Court declares laws unconstitutional or not. That's the power of judicial review. They are reviewing laws to make sure that they go with the Constitution. All right, so now that we know about the power of judicial review, what it is, where it came from, that it's super old and there was a conflict over it, like pretty much everything else, why don't we get started cooking, and then we'll talk a little bit about the notorious RBG, the first female Jewish Supreme Court justice who was sworn in on August 10th, 1993, and she was the 107th Supreme Court Justice of the United States. It's kind of a lot. All right, so let's get cooking. First thing you're going to need to do is you're going to take your pot. I'm going to put it on the stove. So if you're viewing me on Instagram right now, it's going to be a little bit tough for you to see the stove because I haven't figured out how to do this without 2 cameras yet. But if you're viewing from Facebook, you have a good view. All right, so we're going to pour in 2 tablespoons of olive oil. I'm Italian, I don't measure, so I kind of just eye it. That's 1. There's 2. All right, that's beautiful. And one of the things that I like to do when I'm cooking with olive oil is I like to spin it around in my pot to make sure the whole bottom of the pot is covered. All right. So step 1, in our large pot, we're going to heat 2 tablespoons of olive oil until it's very hot. So one thing that I am going to be very careful of is these little tassel-y things. I'm going to tuck them in so that you guys don't get a fire show also. We don't want History in the Kitchen to end in tragedy. All right. On goes the stove. All right, so we're going to heat that until it's very hot. We're going to hold on a minute. We'll talk a little bit about Ruth Bader Ginsburg for a moment, give a little bit of personal history about her. Ruth Bader Ginsburg was faced with discrimination all of her life. In a quote by her, she talked about how she faced discrimination for being female, for being Jewish, for being a mother, and for being a working mother. So Ruth Bader Ginsburg did not have it easy, and growing up, having been discriminated against for being a Jewish girl, really got her into helping the oppressed in her judgments, in her law career as well as in her career in the Supreme Court. She was born on March 15th, 1933, to 2 Jewish parents. Those Jewish parents had parents who emigrated to the United States because they were facing anti-Jewish discrimination in Europe. Ruth's mother, whose name was Celia, encouraged Ruth to work on her education. Celia really wanted Ruth to go to college, really wanted Ruth to succeed, because even though what society expected of Ruth Bader Ginsburg was her to get married, have children, and that would be it, not that that's a bad thing, but Ruth wanted to do something different with her life. And Ruth's mother actually got a job when she was younger, not to send herself to college, but to send her own brother to college. So Celia really wanted Ruth to be able to do that. An example of something that Celia did to encourage Ruth Bader Ginsburg's education was whenever Celia went to go get her hair done, she would drop Ruth off at the library, and Ruth would take home 3 books a week that she would choose while her mom was getting her hair done. And Ruth Bader Ginsburg faced discrimination as a Harvard Law student. She was one of 9 women in her Harvard Law class, and people often used to ask her how it felt to have taken a more deserving man's spot. I can think of no one more deserving of a spot in Harvard Law than Ruth Bader Ginsburg. All right, so my oil is super hot at this point, and the first thing that I'm going to do is I'm going to throw in my zucchini. My zucchini is chopped into cubes. You can see that, and I'm going to throw it in here. You can hear the sizzle, and I'm going to stir constantly for about 2 minutes. I'm also going to be very careful of the oil jumping at me. We don't want to get burned here. So if you are a student who's attempting this recipe, if you're a younger student, if you're not somebody who's used the stove a whole lot, my suggestion is to have an adult around to help you out. All right. So Ruth Bader Ginsburg is known for her career in fighting for women's rights and for other marginalized groups. One of the things Ruth Bader Ginsburg did was she studied Swedish law, and that helped shape her feminist views because in Sweden, the feminist idea at the time that she was studying was that to be human, both men and women had to share parental responsibilities, and they also had to share responsibilities as breadwinner of the family. So there was no such thing as one person doing all of the work. There was no breadwinner. It was an equally shared responsibility amongst men and women. And when Ruth Bader Ginsburg was done studying that, she actually got a job at, Rutgers Newark, which is not super far away from here. I had no idea that Ruth Bader Ginsburg was a professor at Rutgers Newark. I think that's totally cool. And she taught a course called Women in the Law. And in that course, she taught students that there were lots of laws in the United States that either distinguished between men and women or took rights away from women. So, for example, one of the laws that she would talk about or not one of the laws that she talked about, but one of the laws that was on the books at this time was that widowers were assumed to be breadwinners and couldn't get a deceased wife's Social Security benefits. In Wisconsin, female hairstylists couldn't cut men's hair. And in fact, the one piece of legislation that she knew of when she was working at Rutgers Newark in the 70s, the first piece of federal legislation about sex discrimination was the Equal Pay Act of 1963. So Ruth Bader Ginsburg's got not a lot of federal laws on the books to protect women, but she does know of and teaches about a lot of laws that discriminate against women. All right. So our zucchini has been in here, and we're going to lower the heat while we move this, and we're going to take our slotted spoon, and we're going to take the zucchini, and we're going to put it in our big bowl. Now, if you're making a mess, that's okay. Messes can be cleaned up. Just be careful not to burn yourself with the oil. Your zucchini should have a little bit of a golden brownish tint to it. So you can kind of see that it's a little bit golden. Okay. We're going to take it all out of the pot. Now, if you still have a whole bunch of olive oil in there, you're in good shape. You can move on to the next part of this recipe. If you still have enough olive oil in there, this is how much I have. So I'm not going to put in any more. You can kind of see it a little bit. Okay. But if your olive oil is running low, add another 2 tablespoons for the recipe. All right, so over high heat, we're going to saute our peppers and our onions together. These are supposed to be coarsely chopped, so your onions should look like this. I have a lot to say at History in the Kitchen today, so I prepped everything beforehand. I could have spent the entire time on Marbury versus Madison and Judicial Review. It's one of my favorite things to teach. All right, and your coarse peppers should be cut this way. So we're going to put them back in the pot. We're going to saute these together over high heat. This is about 3 minutes, I think. Yep. We're going to stir. Now, if you can flip, go ahead and do that. I already lost a pepper. So if you cannot flip, don't do that. You can feel free to just stir over high heat. All right. So while these are cooking, so Ruth Bader Ginsburg started fighting for women's rights in small ACLU cases in Newark, New Jersey. And basically what she was doing is she was helping individuals. But Ruth Bader Ginsburg knew that there was a systemic problem in the United States. So women were discriminated against, not just on the individual level, but they were discriminated against, and some argue still are, at the institutional level, at the government level. It wasn't just single individuals, it was a system that was working against women. So the first case that she took on that actually changed a law, changed the system, was a case called Moritz versus the Commissioner of Internal Revenue. And this case actually went through her husband's desk first. So they were reviewing cases together, and her husband Marty looked at her and said, "Hey, I have a case that I think that would interest you. You should read this." And what Ruth Bader Ginsburg did is she turned around and she was like, I don't do tax law. And he was like, no, you'll see. So basically, in fall of 1970, Marty gives this case to Ruth Bader Ginsburg. And the man in the case, Moritz, argued that it was unfair to deny him a tax deduction for the money he paid a caretaker for his 89-year-old mom. Okay? His mom was his dependent, and he was a single man. And he argued a single woman would get the deduction in the same situation. Why shouldn't I have that? So Ruth said the law sought to give benefit to people who cared for dependents but couldn't imagine a man doing so. Interesting. So when they took this case to court, Ginsburg argued the constitutional side and her husband Marty argued the tax side, and they won. The court ruled for Moritz in 1972 and said that the code made, quote, an invidious discrimination based solely on sex, and it was against the Fifth Amendment's guarantee of due process. So Moritz wasn't getting due process because he was a man. The law wasn't helping him. He wasn't able to use that law because he was a man. And this is the first time the IRS code was declared unconstitutional in history, based on a case that wasn't even meant to be a case of constitutional law or gender discrimination. So following the Moritz case, we're going to get into a case called Reed versus Reed. So hold on one second, because we're going to turn, once our onions start to get like a little bit clearish, we're going to take our sauteed peppers and onions and we're going to put them in the bowl with the zucchini. Starting to smell really, really delicious in here. Okay. Now also I'm going to take out this one. I burned that one a little bit, so we're going to take out the little burned one. Okay. And at this point, I'm going to need more olive oil because we need 2 tablespoons of olive oil in here at all times. All right, so do that. Mix these together. Smells super good, and the beauty of this is that they're going to continue to cook together because they're hot. All right, 1, 2. All right, let's wait for that to heat up. And the next thing that we're going to throw in there is the eggplant. My eggplant is cubed, as you can see, but I wanted to give you a quick tip for choosing an eggplant. I don't like a seedy eggplant. And by seedy, I don't mean like a sketchy eggplant. I mean an eggplant with a lot of seeds. So you'll see in this eggplant, there are not a lot of seeds in here. If you look at the bottom, you're always going to look for an elongated bottom on here. Never choose one that's the size of a pinprick or like really, really small and round. Because if it's really small and round, you're going to get a lot of seeds. Okay, so Reed versus Reed while we wait for this oil to heat up. So Reed versus Reed is about a law in Idaho. So the Idaho court specified that males must be preferred over females to be the executor or the administrator of an estate after the death of a relative. So after the death of their adopted son, Sally and Cecil Reed sought to be administrators of their son's estate. They were separated at the time, and each of them wanted to be the administrator. The Idaho law automatically made Cecil Reed the administrator, and Sally was like, no, that's not fair. So she brought it to the court. And this case eventually makes its way to the Supreme Court, and the big question of this case is, did Idaho law violate the Equal Protection Clause of the 14th Amendment? So basically, the 14th Amendment guarantees that all laws will apply equally to all people. Now, normally this was based on race. The 14th Amendment was passed to help against race discrimination, but at this point, Ruth Bader Ginsburg is calling upon it, and the other lawyers in the case are calling upon the 14th Amendment to also be used for sex. And they're basing this argument on an argument made by feminist and civil rights activist Pauli Murray. She was an African-American woman who was also in 2017 retroactively labeled as transgender, and she was the first to argue that the 14th Amendment should protect against sex discrimination. And then another woman that she admired and who helped build this argument, or whose arguments helped build the case, was Dorothy Kenyon. She was a feminist. She pushed for ACLU to end sexist practices. She was one of the only the only female board member on the ACLU for many, many years. She worked with Pauli Murray, and she helped write case briefs that challenged sex discrimination in the 40s and 50s. So neither Pauli Murray nor Dorothy Kenyon worked on these arguments in Reed versus Reed, but Ruth Bader Ginsburg credits them because she based a lot of the arguments that she wrote on their work. So in a unanimous decision by the Supreme Court, they said dissimilar treatment of men and women was absolutely unconstitutional. But they did not, however, allow for strict scrutiny of laws that seemed to discriminate by sex. And what that means is that strict scrutiny is the most stringent form of judicial review. A judge can strike down a law unless the government can prove that it is necessary to a compelling state interest, it is narrowly tailored to achieve that interest, and it uses the least restrictive means to achieve its purpose. So strict scrutiny is used in cases to determine racial discrimination, but the court did not apply strict scrutiny and said strict scrutiny wouldn't be applied to sex discrimination cases. So the ACLU established the Women's Rights Project. Ruth Bader Ginsburg was the leader of that, and it was meant just to persuade the courts to look at sex-based cases as suspect and held under strict scrutiny. So Ruth Bader Ginsburg, even as a lawyer, before she becomes a justice on the Supreme Court, is really invested in women's rights and making sure that sex discrimination doesn't happen. All right, so let's do a little bit more of our recipe, and then we'll talk about some of her Supreme Court decisions, and I'll also tell you a little bit about the collars. Okay, so throw the eggplant in there, and we're going to put the eggplant on high heat. And we're going to stir that eggplant for 3 minutes. If your cube eggplant is a little bit bigger than 3/4 of an inch, I know that's pretty specific. It's okay. We want your ratatouille should be chunky. It's a really nice French peasant dish. All right. So as a justice, I chose a few of my favorite RBG cases to talk to you about, where she was involved in the decision. She's not always on the side of the majority, though, which is why she has a dissent color. All right, so in the United States versus Virginia in 1996, the Virginia Military Institute was the last all-male public college. And public colleges are not to be same-sex because unless there can be something that's, they argue something that's equal, separate but equal, which we all know we're over it. There's no such thing. So Virginia argued that women weren't suited for the Virginia Military Institute's rigorous training. Women just couldn't do it. Pardon my eye roll. And that they had a separate military program at the women's only college, Mary Baldwin University, and that was equal enough. Ginsburg was like, no, actually, your arguments are not valid, and here's why. The goal of producing citizen soldiers through VMI's implementing mythology was inherent. They said that it was inherently unsuitable to women. And she's like, no, there's no such thing as something that's inherently unsuitable to women. Okay. Secondly, she said that you can't make generalizations about the way women are. So VMI, you can't do that. You can't just assume that a woman is a certain way. And lastly, she said you can't make estimates of what's appropriate for most women. So there's no way to justify denying an opportunity to women whose talents and capacities place them outside the average description. So basically, she told VMI, you're going to let women in because they're just as capable. You can't make those kinds of overarching overarching assumptions. All right, let's keep working on this eggplant. I have to add a little more oil because my pot is dry. There we go. That's better. Beautiful. Okay. Now, Ginsburg, a scent color. Looks like this. This is her scent color. It was a gift from some of her law students. Okay, so when she is part of the majority and she agrees, she wears that collar. All right. Next, Bush v. Gore, 2000. So fun story about the 2000 election. I was at an NSYNC concert and I was 16, and here's how nerdy I was from the beginning. Justin is like practically sweating on me, and all the girls around me are screaming, and I couldn't wait to get out of there to find out what happened in the election. Well, nothing. Nothing happened in the election because there was a problem counting the votes. So in Bush v. Gore, President George W. Bush petitioned to stop a Florida Supreme Court mandate for a manual recount of ballots in the 2000 election. And the Supreme Court said, yeah, you know what? Don't recount them. Bush wins Florida. Well, out comes Ruth Bader Ginsburg's scent collar. She is not happy. This is actually from Banana Republic, in case anybody was curious. Her dissent collar is a bid from Banana Republic. And while the Supreme Court made their majority decision, she said that she dissents. And when she made her dissent in this case, normally, before 2000, a Supreme Court justice would write in their dissent, I respectfully dissent. Not Ruth Bader Ginsburg. RBG was like, I dissent. No respect given. All right, let's take this eggplant out of the pot. I'm really enjoying this recipe today. It's very rare that I get to do one where I cook something. And I'm super happy to be cooking. Not that I don't love baking, because I do. All right, we're putting the eggplant in with the peppers, onions, and zucchini. Your kitchen should be smelling delicious at this point. If it doesn't, you're doing something wrong. Just saying. All right. So the next part of our recipe is over medium heat. We're going to throw in the garlic. If your pot's getting a little dry, pour in a couple more tablespoons of olive oil. Okay, olive oil. All right, so you're going to take your garlic. It should be minced very, very fine. Okay? And also Italian, I'm cooking with my hands. All right. And this is only about 5 seconds on the heat. I actually have the heat in my pot off so that I don't burn the garlic. And then we're going to throw in a half a teaspoon of thyme. I'm using dried thyme leaves today. And when you use dried anything, you always put it in your hand first and then you crush it in to get the flavor out. So we're going to do that. Okay. And we're going to stir these together. That smells really, really good. Okay. Now we're going to add our tomatoes. You should have saved the seeds. You should have the whole nice big chunks of tomato. These smell so good and they're nice and ripe. Put these in here. We're going to be very gentle with our tomatoes because they can break. All right. So another case that I like to talk about with where Ruth Bader Ginsburg was on the bench and where she had something super awesome to say is a Bergeville v. Hodges, the case that legalized same-sex marriage. There's actually a History in the Kitchen episode about that if you look at some of the back episodes. And Ginsburg was actually a former officiant for same-sex weddings, and she was a promoter of LGBTQ rights even before Obergefell. And basically, she said that marriage was once a relationship of dominant male to subordinate female, and in 1982, the court struck that down. They changed the meaning of marriage. So if you're arguing that you can't change the meaning of marriage and that marriage means one thing, well, there's precedent. The court already changed the meaning of marriage in 1982. Secondly, she struck down the argument that marriage is for procreation because she said, well, a heterosexual couple in their 70s can get married, and they're definitely not going to procreate. So you can't make that argument either. So she is a strong proponent for LGBTQ rights. All right, another cool one. I'm going to keep sauteing these tomatoes over here. All right, and now before we talk about Ledbetter v. Goodyear, let's put all of our vegetables into the pot. All together. We're going to stir and simmer, so turn down the heat. And we're going to stir and simmer for about 3 minutes. Oh, this looks so good. I think it might be time for a slightly larger saute pan. All right, so in Ledbetter v. Goodyear, Tire and Rubber Company, 2017, she wore her dissent collar. And Lilly Ledbetter was a woman who worked for the Goodyear Tire Company for about 19 years, and she sued because she'd found out that she'd been paid less than the males, and alleged that it was because of gender. The pay disparity is, so anytime that there's a difference between the pay of a man and a woman for doing the same job, it's a violation of Title VII of the Civil Rights Act of 1965. But Goodyear said that the complaint had to be filed within 180 days of them not paying her properly. Otherwise, it didn't matter. So Lilly Ledbetter had 180 days to make a complaint about 19 years worth of unequal pay that she didn't even know about. So what Goodyear argued is that Ledbetter could only complain about the last 180 days leading up to her initial complaint and not the 19 years of her employment. Okay. The court ruled in favor of Goodyear in a 5-4 decision. And Ginsburg was like, what? She pointed out that Ledbetter couldn't file sooner because she didn't know. And she said that the version of her dissent was easy for people to understand. So there's a dissent that has like technical language that gets filed, but she read from the bench and she made it really easy for people to understand. And she outlined the gender wage gap, and she pressed Congress to amend that part of Title VII. She was like, it's ridiculous that there's only 180 days when a woman has been unequally paid, or couldn't figure out that she was unequally paid, or couldn't find out because employers keep pay private for many years. And by pressing Congress from the bench, Congress actually changed the law. They took that 180-day thing out of Title VII, and it's called the Lilly Ledbetter Fair Pay Act. So even though Ruth Bader Ginsburg was in the minority, she still made change. All right, the last one that I want to talk to you about is about voting rights, because we're getting really close to the election. The election is November 3rd, and while this case happened in 2013, we also want to be on the lookout and make sure that everybody in our country who is registered and who is a citizen of the United States can vote in our elections. Everybody in this democracy has the right to vote if they are a citizen. No ifs, ands, or buts about it, and nobody can convince me otherwise. So Shelby County v. Holder 2013 is about the Voting Rights Act, but the Voting Rights Act is a very big law, and it actually only goes after a part of the law called Section 4. Let's give this a start real quick. Then we're going to take it off with you. So Section 4 of the Voting Rights Act establishes something called a coverage formula in different states to determine which states and local governments need to get approval before changing voting laws. So before they change a voting law, they need something called pre-clearance. And this Section 4 applied to Alabama, Georgia, Louisiana, Mississippi, South Carolina, Texas, Virginia, Arkansas, Arizona, and some parts of other states. And it was meant to protect minority voters. It was meant to protect black men and women and make sure that they got their voting rights in light of Jim Crow laws that kept them from voting, either through literacy tests or poll taxes or ID requirements, lots of different things to keep people from going to the polls. And the court actually ruled that Section 4 is unconstitutional because the conditions that originally justified these measures no longer characterize voting in the covered jurisdictions. So basically they were like, yeah, racism's gone. I've been making this face a lot in this episode. So Ruth Bader Ginsburg was like, the majority completely misread the lessons of racial progress in the United States. When you are confronting, and these are her words, when you are confronting the most constitutionally invidious form of discrimination and the most fundamental right of our democratic system, Congress has the power to act at its height. So Congress must be able to help people vote when it can. And she was like, the court totally misread that, and I 100% dissent. And Ruth Bader Ginsburg was also kind of reading the room because in 2006, the Voting Rights Act and the use of Section 4 was unanimously approved in the Senate, and George W. Bush signed it into law. So it was nonpartisan, and minority rights in voting were not protected, because as soon as this part of the law was struck down as unconstitutional, Texas and Virginia started talking about having to present voter IDs for that. And voter IDs aren't necessarily accessible. It's not something that everybody can get. It's something that you have to pay for. So Ruth Bader Ginsburg was really looking out for the rights of all people to be able to vote in our democracy. So Ruth Bader Ginsburg is really important because she tries to protect those who need protecting, and make sure that things are fair to people who in general have not been treated fairly in the United States. So, tribute to RBG. This is her very first collar. It's French, and the reason she decided to wear it, she and Sandra Day O'Connor actually talked about wearing collars, and the reason is because if you look, a justice's robe is meant to show a necktie. It's a male garment. So they added the female accessory to it. All right, everybody, this was today's History in the Kitchen. If you want to add your parsley, you can add some parsley to this before you take it out of the pot. Give it one more quick stir, and you have some of the Ginsburg's Ratatouille. Okay, yum, and then you can serve this. Now you can add some salt and pepper to taste. I'll add a little bit of salt and a little bit of pepper, because my family likes that stuff. Give it another quick stir. Yum-o. All right, take a look at this. This looks delish. All right. Thank you so much for joining me this week on this week's History in the Kitchen. If you made any comments or had any questions during this episode, I will get to them as soon as we're done. I can't see them right now. And if you would like to follow me, please find me on Instagram and Facebook at Teaching History Her Way. TeachingHistoryHerWay.com is my blog. You can get all of today's information. And I also believe I said the Voting Rights Act of 1965. I meant 1964. Excuse my faux pas. You can also find me on YouTube if you want to take a look, Teaching History Her Way, or on Twitter, History Her Way. I can be found in lots of places on social media. And also, if you have a suggestion for an episode of History in the Kitchen, I would love to hear it. Today's episode came from my very best friend, Meredith Forte. She wanted to hear about RBG, so Mara, this one was for you and for Livy. And also, I have a couple of Teaching History Her Way aprons, so if you would like one, I'm thinking about throwing up an Etsy store so that you can grab some Teaching History Her Way stuff, because I've been having a lot of fun making things over the summer. So I will see you next week. Same time, same place, Saturday at 3 p.m. I hope you enjoyed today's History in the Kitchen, and I cannot wait until next week. Have a wonderful weekend. Bye.